So my name is Geoff Sigalet. I'm a postdoctoral fellow and a lecturer in law, not quite a professor yet, so I hope to change that soon. And it's my pleasure today to chair this panel on the Notwithstanding Clause. The Notwithstanding Clause, as most of you know, is found in Section 33 of the Canadian Charter of Rights and Freedoms. It's a fairly unique instrument in constitutionalism around the world. I don't think there's any other constitution with anything quite like it. And what it does is it allows Canadian legislatures, both the provincial and federal legislature, to enact laws that are valid notwithstanding certain sections of the Charter. So it doesn't apply to all the Charter rights. So it doesn't apply, for example, to Section 3 rights to democratic rights to vote, which is part of why Parliament couldn't respond to the Shrank decision just handed down the other day with a statute with notwithstanding provisions. But it does allow Parliament and the provincial legislatures to potentially reply to judicial decisions or to preempt judicial decisions even about charter rights and protect, can everyone hear me? And protect legislation from judicial invalidation for a period of at least 5 years. After 5 years, notwithstanding provisions expire, but then can be reenacted. And there is no limit on the number of reenactments that can take place. So one of the reasons we're up here discussing the Notwithstanding Clause today is that it's been in the news a bit more lately. So in 2017, the Saskatchewan Court of Queen's Bench struck down parts of a statute allowing funding for non-Catholic students to attend Catholic schools as a violation of religious neutrality and the Charter right to religious freedom and the Charter right to equality. And the Saskatchewan government of Brad Wall then announced that they would respond to this using this really controversial section of the Charter and include a notwithstanding provision in a statutory response protecting funding for non-Catholic students to attend Catholic schools. And the Moe government, since then, Brad Wall has stepped down as leader of the Saskatchewan Party, has actually followed through with that promise and enacted a law that includes notwithstanding provisions. And it's the first use of the clause in a long time. Since then, Ontario has had a very interesting recent experience with the notwithstanding clause in response to a judicial decision invalidating a provincial act that shrank the Toronto City Council. The Ontario provincial government tabled a bill that I think got to the second reading that included notwithstanding provisions throughout that was to be enacted and would have been valid regardless of, in the face of that decision, would have applied notwithstanding the sections of the Charter that the Ontario Superior Court used to invalidate the original statute, shrinking the city council. So that bill wasn't fully enacted because the Ontario Court of Appeal actually stayed the lower court decision. But it's another interesting potential use of the notwithstanding clause in recent times. And the third instance of the notwithstanding clause in the news recently has been the newly elected Premier of Quebec, François Legault, has promised to use the notwithstanding clause to protect a new charter of values, enforcing a form of laïcité on Quebecois public servants. So we've yet to see any actual action on that, I think. But each of our discussants today are going to tell us a little bit about their views of the notwithstanding clause, how they understand it in Canadian constitutionalism, what they think about it normatively, and maybe how it relates to some of these recent cases we've seen in the news. So let me just really quickly introduce each of them, and then we can get to their comments on these matters. So first, we have Andrew Coyne, who is a very well-known columnist in the National Post. Second, we have Carissima Mathen, who is the Vice Dean and Professor of Law at the University of Ottawa, and is writing a forthcoming book on the Courts Without Cases, the Law and Politics of Advisory Opinions. It has another book project with Professor Michael Plaxton at the University of Saskatchewan on the Nadon reference, right? And she was telling me about it before this talk. It sounds very interesting. Third, we have Emmett Mcfarland, who's an associate professor of political science at the University of Waterloo and a star on the website known as Twitter, I think. His book is called The Supreme Court of Canada and the Judicial Role. And he's the editor of a new book called Constitutional Amendment in Canada, which I personally found very useful in my own research. So fourth, we have a lot of panelists today. For our fourth panelist, the one sitting closest to me, is Professor Dwight Newman from the University of Saskatchewan. He's a professor of law there, and the Canada Research Chair in Indigenous Rights in Constitutional and International Law. And he's also been the Associate Dean of that school, that College of Law. And he has been a visiting fellow at Princeton, where I had the pleasure of meeting him, actually, Cambridge, and Montreal. So why don't we start with Professor Mathen, if that's all right.
Thank you very much. I'm delighted to be here, delighted to be back with this group. I was last here in 2015, debating none other than Andrew Coyne on the Supreme Court Act reference. The reference that nobody can let go of, I noticed by the discussion last night. So I've always felt a bit like the odd person out in debates over the Notwithstanding Clause, because even though I am a staunch defender of the judicial role in rights adjudication, I've always been less bothered by the Notwithstanding Clause than other persons with similar views to mine. At the stage of constitutional design, I probably wouldn't choose to include it, but I don't think its presence in the Charter necessarily makes a mockery of the entire project. I accept that rights determinations by courts is far from a science, may not be amenable to defense on grounds of correctness. And I also think constitutions are as much an exercise of pragmatic social ordering as grand principle. And there's no inherent or universal way to combine those very real and occasionally conflicting interests. That being said, recent events have given me cause for concern. And so I'll just make a few preliminary points. The first is I note, over the last number of years, it had become really de rigueur to proclaim Section 33 defunct. Interestingly, this argument tended to come more from those who were generally suspicious of the Charter and thus would be sympathetic to use of the override, as opposed to those who were actually interested in rendering the clause spent. The explanation for this, I think, was multifaceted. Part of it was the specific structural features of Section 33, in particular that its wording suggests that the legislature must be prepared to actually override rights, as opposed to simply enabling a particular interpretation of them. And part of the pattern, it was observed too, was really traceable to specific historical factors about the prior uses of Section 33, most notably that by Quebec, which it was thought had soured the rest of the country on the clause, as well as the consistent reluctance to use it at the federal level. Well, I think we can safely say that rumors of Section 33's death were greatly exaggerated. 2 provinces now have invoked it in the space of a year, and the clause was seriously mooted during the leadership convention of a major federal party. It's too early, far too early, I think, to say whether invoking it will become routine, but at the very least, it has reemerged as a potent political issue. So if we are in this new period, if Section 33, in fact, never left the building, what does that mean? Well, defenses of Section 33 often paint, in my opinion, a rather idealized picture of the legislature as a careful laboratory of principled debate, where a determination to use the clause emerges only after sober consideration, and on the kinds of issues on which disagreement is reasonable and anticipated. There have been very thoughtful accounts in this regard, including by some of the strongest proponents of the clause in 1982. I would diverge a bit from this view. Now, I don't think the sky is falling just because we have some political actors recently who have been willing to use Section 33. And in my scholarship, I've recognized the legislature as entirely capable of rigorous constitutional analysis. But I think we do need to seriously question the bases for these rather rose-tinted predictions about how the clause will actually be used. The way that the Government of Ontario, for example, announced its intentions to use the clause suggests something quite different. And while it took a more measured tone, the Saskatchewan government's decision to use the clause, in my view, was not much more persuasive. And I tend to agree with Professor Leonid Sirota, who took a somewhat dim view of those stated reasons. More to the point, I'm not really sure why we would expect something different. It is hard to imagine a more polarizing topic for debate, certainly after a court loss, particularly if that loss was unexpected. The idea that this will be followed by high-minded analyses, careful invocation of separation of powers, perhaps reliance on theories of coordinate construction, it seems a little fanciful. Given the nature of politics, and particularly given the nature of our politics today, it's going to inevitably be much easier to resort to much simpler terms, framed mostly in terms of majoritarian interests. This is important to us because it's important to you. It's much easier to invoke a specter of elite, unaccountable judges running amok over the people. It's easier to simply paint certain groups as less worthy of respect and regard. In Quebec, as Geoff mentioned, dealing with a law regulating religious dress, the government has been very blunt, refreshingly so perhaps, justifying the use of the clause, should that become necessary, precisely because of how popular the law is. Should its use become more common, there seems, I think, little question that Section 33 eventually will be invoked in ways we will and should find discomforting. It will target deeply unpopular groups who are structurally disadvantaged in ordinary politics. And once governments begin to use it, they will face increasing demands to do so, and those demands may be very difficult to resist. The final point I want to make is this interesting debate that's arisen around Section 33 as a means of last resort or first resort. Recent events confirm the previous pattern that Section 33's use will be preventive or preemptive, what some people consider even premature, and not merely reactive. That is to say, it is and will be just as available at the legislative drafting stage or in response to a single lower court decision as to a final appeal rendered by the Supreme Court of Canada. In one sense, that may not be all that bad. It's quite possible that preemptive use will actually provide more space for the kind of reflection that, say, the 1982 Constitution's framers would have expected to attend an eventual use of Section 33. Once a court decision is on the table, by contrast, the government or legislature will face much different pressures to act that may impede the full flowering of such deliberation. And another point I've been thinking about is the idea that once any actor enters the adjudicative context, it's a core assumption that it is willing to accept the result, subject, of course, to appeals and so forth. I think that's a really important notion, and we should be cautious about regularly upending that. If the legislature does in fact have coordinate power to interpret the Constitution, and it has the ability, vouchsafed by the Constitution, to enforce that interpretation, then it seems of no consequence whether a court might happen to agree with that interpretation. The only reason to persist is to obtain judicial imprimatur. But that seems contradictory to the very genesis of the clause, and I think may well have undesirable effects that the government itself may not welcome. Thank you.
All right, I'll just pick one of them. Dwight's going to reply.
Okay.
Or just give us, and we'll have about 10 to 15 minutes for them all to discuss each other's views, and then we'll open it up after each participant's gone.
Okay, well, good afternoon, and thank you for having me here to talk about this topic. And just before I start, I'll say, if you want to see my fuller views on it, I do have a forthcoming book chapter on the Notwithstanding Clause in a book edited by Geoff and two co-editors. So buy Geoff's book, and all will be well. But I'm going to say a few things about my thoughts on it. And having just come through exam season as academics, there's always that annoying student somewhere in the class that wants to start off by criticizing something about the way that you've asked the question. And so I'm going to follow in that line, actually, and say if you look in the program, you'll see that the question asked is notwithstanding clause, dead letter or loaded gun. And I want to say this is a false alternative. It repeats two common myths, one of which is that the notwithstanding clause is in some way taboo, and the other of which is that in some way it's dangerous. And I'm going to suggest that neither of those is inherently the case, that rather it's an important part of the Canadian Charter that should play a role in balancing between judicial and legislative interpretations of charter rights, that a reinvigorated use of the notwithstanding clause has the possibility to reinvigorate parliamentary democracy, and that it can be appropriately constrained in its use within a responsible parliamentary democracy. And to try to show those things, I'm going to say something about how to interpret the notwithstanding clause, drawing upon its text, drawing upon its history, and drawing upon its philosophy, the three types of things that are very prominent in constitutional interpretation when we engage in it. So, thinking first of the text of the notwithstanding clause, we actually need to think of the text of the Charter. And what I would point to here is that the notwithstanding clause sits alongside a set of charter rights, but sits alongside them as a provision by which, in certain cases, the Parliament or legislators can make a determination on the effect of those charter rights. Now, there are many false claims circulated about the notwithstanding clause. Every time something happens in Canada that somebody doesn't like, someone will say, invoke the notwithstanding clause, whether or not it legally applies to that situation or not. It's just sort of a general get-out-of-jail-free card, as it's been called. And it's obviously not that. It's a clause that allows a temporary enforcement of parliamentary or legislative decisions in relation to particular statutes and in relation to certain of the rights in the Charter. It doesn't apply vis-a-vis the democratic rights within the Charter, for example, and that's very important to realize because it itself is subject to a democratic check. And so that's very important in terms of the structure of the Charter text and the place of the notwithstanding clause within it. If we engage in a balanced reading of the Charter text, the notwithstanding clause is a tool that can be used in some instances. It would be wrong for it to be applied all the time. And why is that? Well, it would render the other clauses of the Charter that it's used against irrelevant if it were used in every instance. So it's obviously not meant to be used routinely, but it's also, there's nothing in the text that suggests that it's there as a clause of last resort. It's a clause that's part of the Charter, along with other clauses in the Charter. It can be a flexible instrument. In many ways, it is an entirely flexible clause within the Charter. There are very few constraints on its use within the constitutional text. There is a 5-year limit to ensure the democratic check on it, and it's subject to that democratic check. And in many ways, it should be regarded as a flexible instrument if we look simply at the text. But I'll reinforce that by talking about the history of the notwithstanding clause. And here it's very important to talk about what happened in 1982. First of all, the Notwithstanding Clause was an essential part of the deal in 1982. Without the Notwithstanding Clause, there would be no Constitution Act 1982. Several of the provinces were not willing to sign on to the Charter without the presence of the Notwithstanding Clause within it. So I actually put the position that anyone who does not respect Section 33 as an appropriate part of the Charter actually should not be urging respect for the Charter at all, because it would not be a legitimately adopted instrument without the presence within it of the Notwithstanding Clause that was part of the deal. It received support from very different sorts of people from a partisan type perspective. The strongest proponents were on opposite sides of the political spectrum and included particularly Saskatchewan's NDP Premier, Alan Blakeney, and Alberta's Conservative Premier, Peter Lougheed. And they had something that went beyond a partisan view. They were both very much oriented to parliamentary traditions, the traditions of a parliamentary democracy, and saw the Notwithstanding Clause as something that could serve as a balance between the adoption of an American-style system and the maintenance of respect for a traditional British parliamentary democratic system. And that's a very important balance that was struck. It's a very important guarantee that was included within the Charter that struck that kind of balance. And I think we can learn a lot by looking at what these proponents of the Notwithstanding Clause actually had to say about what the underlying philosophy of it was. And I'll just say the text of it was not entirely new in 1982. It wasn't some last-minute addition. It was discussed over the years leading up to 1982. It drew upon prior texts of other instruments. And so it was an accessible idea and one that was ultimately adopted. And why was that? Alan Blakeney wrote an article several years later where he explained the main philosophy of the Notwithstanding Clause as he saw it, which was that it pertains to ensuring that parliaments and legislatures can continue to act in support of rights that are not enumerated in the Charter, even in circumstances where that runs into difficulties vis-à-vis rights that are in the Charter. And unless you have a very impoverished view of the human condition, it would be a mistake to think that the Charter includes every right that might be pertinent or every moral consideration that might be pertinent. Alan Blakeney recognized this. He recognized that certain rights are in the Charter because it makes sense to have those rights judicially enforced, but there are many other important rights, moral rights, political rights, and other moral considerations that it doesn't make sense to have judicially enforced, but that it would be appropriate for politicians to pursue through legislative action, and where they might then use the Notwithstanding Clause in some instance to do so, where that ran into difficulties on account of the Charter. Peter Lougheed, in an article a number of years after the Charter was adopted, offered his explanation of what it was that was going on with the Notwithstanding Clause. It has connections, but it emphasizes a different point. And Lougheed emphasized the idea of erroneous judicial interpretations and situations where there might be divergence from that by parliamentarians and legislators. And this is one of the foundations that's often mooted, I guess. I would actually say it's present in several of the recent uses, that we are seeing instances where governments decided to overcome a particular judicial interpretation that was highly contestable on the law, with the additional element that the circumstances made the judicial decision particularly impractical at the moment when it was being enunciated. And I'll say that about both the Ontario and the Saskatchewan examples. So I'm going to first go out on a big limb in this room and say that I'm going to defend what Brad Wall did. And I know defending Brad Wall in this room is a sensitive position, but I would say that in respect of the Saskatchewan use, there was a decision by a court that was highly contestable on legal grounds, to say that it was a violation of the religious freedom of students who didn't complain about a religious freedom problem in the context of a funding dispute between two school boards, as were the facts of the case, is something that would be very much subject to appeal. But the effect of the decision in the Saskatchewan schools case is that even with a 1-year suspension of the decision, parents and children were put on notice that a year from now you're going to have to move school. And so children that might be starting into a school probably wouldn't start into that school if they had to be moving from it in a year. Parents might take preemptive action in some instances. The effects would have been dramatic even with a suspended declaration. And so the use of a notwithstanding clause move in order to bring stability in the meantime, to bring certainty in the meantime, while things get sorted out on this issue, responded both to a situation of judicial interpretation that was potentially problematic and responded to the practicalities of the situation. In Ontario, things were not explained as well in that way as they could have been, but the idea that a judge would disrupt a municipal election in the middle of the process with a highly contestable decision on Section 3 of the Charter, developing elements to Section 3 that simply weren't there, and would be permitted to disrupt a municipal election process in doing so, I don't think it's an unreasonable step for a government to respond using the notwithstanding clause to create stability in the meantime and to take that on to appeal. I don't know anything about what would be a good way or not a good way to elect municipal councillors in the City of Toronto. I take no view on that, but I think that the use of the notwithstanding clause fits these kind of criteria in a plausible way. The other thing that I would say is that the notwithstanding clause permits variation in Canada, permits diversity in Canada by the fact that within the structure of it, it can be used not only by the federal government, but also by provincial governments. It actually hasn't been used by the federal government, and that's perhaps not surprising. There's more diversity in the provinces than there will be within the federal government, in a sense. And so certain provinces have at times taken different views on how to go about dealing with certain types of rights. And that's something that the notwithstanding clause permits and provides for. And Quebec is a very different province than other provinces in Canada, to state the obvious. I profoundly disagree with some ideas that Quebec talks about on laïcité and the views that that leads to on religious freedom. But I also don't actually take the position that hundreds of millions of people in a number of Western liberal democratic states live in tyrannical systems when they also take views similar to laïcité in a number of European countries. I think there are significantly different views about the correct ways of going about protecting religious freedom, but if Quebec adopts a very different model and uses the notwithstanding clause after a long series of debates about those issues in Quebec, I think that that's possibly something that can be defended. And there's a lot more that could be said on the complexities of that, but I actually don't think we're seeing abusive uses of the notwithstanding clause in anything that's happened thus far. People could worry, would there be others down the road? What we really need to have is stronger parliamentary and legislative traditions, and rights existed before the Charter of Rights existed. Rights existed within the long traditions of parliaments and legislatures. And today we're all too ready to speak of parliaments in infantilizing ways. We're ready to say that parliamentarians can't make sensible decisions and need the supervision of courts in every instance. And every time that parliaments say they're not going to deal with an issue and they're just going to send it to the courts to resolve, they infantilize themselves. This is a concerning phenomenon when parliaments take up responsibilities and engage with these difficult issues that they can engage with under the Notwithstanding Clause. It actually calls for more responsibilities on parliaments, more responsibilities on citizens, more responsibilities on all of us to talk about rights in ways that are sensitive to the circumstances of all other citizens, and not to leave that job simply to the courts to do. It's a job for all of us to protect rights, and the Notwithstanding Clause actually provides a way in which we can all live up to that responsibility. So I'll leave it there, but I offer a defense of the Notwithstanding Clause.
All right, thank you very much, Professor Newman. Next on deck, I think we have, or in the other corner, I think we have Mr. Coyne. So.
Thank you very much. When Ontario Premier Doug Ford announced he would invoke Section 33 of the Charter of Rights to preserve Bill 5, legislation abruptly halving the size of Toronto City Council in the middle of an election campaign from judicial scrutiny, it caused an enormous furor, not least among the clause's more liberal defenders. This was not what the clause was supposed to be about, they protested. It was supposed to be a safety valve, to be used only in a constitutional emergency. Even the clause's authors, the aging statesmen who negotiated the accord that allowed the charter to pass into law, entered the fray. This was not how we ever imagined it would be used, they said. I can sympathize with their dismay, but I have to ask where these people have been. Ford is hardly the first premier to have used the clause or have publicly threatened to, or at the very least privately contemplated it. Neither will he be the last. And the more typical instance of its use has not been in the rarefied circumstances certain of its proponents imagine, in which there is simply no other way to preserve the democratic will from being permanently thwarted by a runaway judiciary. The more usual scenario has been to beat up on an unpopular or inconvenient minority. As, for example, when the Alberta government attempted to invoke it to prevent 3,000 former mental patients from suing it for having been forcibly sterilized while in the province's care. Or when Quebec used it to preserve legislation banning a minority group's language from public display. The current Premier of Quebec as mentioned, is suggesting he'll use it to preserve legislation that effectively bans observant members of religious minorities from certain jobs in the public service. They do all this because they can, because it's available to them. I imagine the state of Kansas would have liked to have been able to avail itself of a similar clause to get out from under Brown versus Board of Education. I'm not sure that would have been a great moment in the history of human rights. Come down from the mountaintop of abstraction to the real world of politics, and the clause is revealed in all of its thuggish particulars. It's not about judicial activism or parliamentary sovereignty. It's about specific rights being denied to specific people. To affect dismay at governments using or even abusing a power that has been given to them strikes me as foolish or even disingenuous. You leave a loaded gun lying around, somebody's bound to pick it up and use it. Indeed, the very existence of the clause is a standing invitation to its use. The rights that we have so gaudily guaranteed in the Charter, it says, are not, in fact, guaranteed at all. They're not permanent and universal, but temporary and contingent. Not even rights, really, so much as permissions. And what the government gives, the government can always take it away. It is, as Eugene Forsey once put it, a dagger pointed at the heart of the Charter. Whether or not it is ever invoked, it is always at work, undermining the Charter's legitimacy, sapping our commitment to the principles it espouses. For as long as it is part of the Charter, it will remain a light in the window for partisans of arbitrary rule, and there are probably a few in this room who would like to see the clause invoked routinely, because they have never come to terms with the Charter and see it as a means of essentially eviscerating it. Perhaps the presence of such a clause might be considered an unavoidable necessity if the rationale for its continued presence were otherwise valid. But in fact, the supposed clash between parliamentary supremacy and judicial supremacy, so often invoked in its defense, the nightmare scenario of a democratic parliament being stonewalled by a runaway Supreme Court, is a work largely of the imagination. Ours is not a system of either parliamentary or judicial supremacy, but of constitutional supremacy, and has been since 1867. Courts were overturning bills passed by the legislatures on division of powers grounds long before the Charter came along. No Notwithstanding Clause was around to save them. All the Charter did was let the public in on the game. Governments were not just prevented from encroaching on each other's turf, but also upon the citizens. And who decided that that should be the case? Parliament, with the support of the provinces. The Charter was not dropped on us from a passing jet. It was itself an act of Parliament. It was Parliament and the provinces who assigned the courts the role of scrutineers, examining the laws for their compatibilities with the higher law of the Charter. The reason for this is not that the courts are infallible. Neither are the legislatures, you may have noticed. Neither is it inspired by a belief that the courts are or should be above the legislatures. It is rather that the courts are other than the legislatures, a second set of eyes, an independent arbiter. The Charter and the rights contained in it was a promise. We will pass no laws that defy this law, but a promise of an unusually binding kind, rather like an oath. And to make an oath meaningful, you have to have a court to enforce it. That's, by the way, the role of the rule of law generally. That's why we make governments put it in writing, is we want to bind their discretion. We want to subject it to outside supervision. We don't want them just to be able to do whatever they feel like doing in the moment. To instead leave governments to decide for themselves whether their laws were in conformity with the Charter, whether they had kept their promise, seems to me to amount to letting them vouch for their own credit. Worse, the Notwithstanding Clause allows them to simply break their promise. To be sure, they must do so openly, and they must do it again every 5 years. But this is cold comfort, I submit, for the victims of this breach of trust. And neither is it a given that a government would pay a political price for beating up on a defenseless minority in this way. In times in our history, it's proved quite popular, and I don't mean only in our history. The question is not, as it is often put, who will have the final say. In our system, nobody gets the final say. It's rather more in the nature of a conversation. A judicial finding that a law is unconstitutional does not typically put an end to it. More often, that's the beginning. Decisions almost never turn on whether a law is valid in principle, i.e. in its very purpose. They're about whether in pursuit of its purpose it overreached. Courts don't often insist that a law may not breach Charter rights to any degree, no matter how slight, just that it infringe rights only to the least extent necessary to achieve its desired end and in proportion to the good thus achieved. Likewise, courts usually don't find fault with the whole of a law, only with particular sections of it. It's then open to the legislature to redraft the offending section to the extent of its overbreadth. Framing this process then as a simple matter of courts versus Parliament, rather than courts working with Parliament, seems to me to be a distortion. Do judges sometimes get it wrong? Of course. But the notion that they always lean, so far as they err, in the direction of overturning legislation is simplistic nonsense. As often as not, they duck, deferring to the legislature when they ought to have stood firm. If you really want to see judicial activism, have a read of the contorted rationales the courts commonly offer for upholding plainly unconstitutional legislation that they happen to like. The Notwithstanding Clause is supposed to prevent courts from overreaching. But what's to prevent them from underreaching, from activism by omission? The courts typically do so, of course, by resort to the Reasonable Limits Clause. It may fairly be asked why we should also need an Unreasonable Limits Clause. A Reasonable Limits Clause is at least reasonably limited. The courts are obliged to apply some test of reasonableness guided by previous jurisprudence, however attenuated that may sometimes become. Whereas no such minimal impairment or proportionality tests apply to the Notwithstanding Clause. The difference between reasonable limits and notwithstanding, however, is not between one branch of government and another, but between laws that invite the scrutiny and participation of both branches, judicial and legislative, versus laws that involve only the one and not the other. If the courts decide that a given law unreasonably limits Charter rights, Parliament always has the option of redrafting the law in a way that achieves the same objective but at less cost to rights. Whereas the Notwithstanding Clause ends the conversation. It removes the law from all judicial scrutiny. I don't think that's a balancing act. I think that fundamentally imbalances the process. I grant the obvious, the notwithstanding clause is in the Constitution. It's part of the very charter it overrides. That doesn't mean I have to agree with it or consider its use legitimate. Certainly there's no obligation, it seems to me, to accept it simply on the grounds that it was part of the political deal that brought the charter into being. Whatever the balance of political forces may have been at the time, and whatever grubby compromises and last-minute horse trading these may have necessitated, we are not obliged to remain their prisoners forever. We're allowed to progress. You know, there's some pretty strange clauses in the U.S. Constitution that were part of the deal. I don't think I need to enumerate them. That I think we should be glad that they progressed beyond. So I don't think we have to say whatever was the terms of that agreement between those people at that time, nothing can be done to change that ever in the future. If we cannot abolish the notwithstanding clause, we can at least abstain from using it with a view, I hope, to delegitimizing it over time. That may or may not be how things turn out. That's what forums like these are for. But there's nothing wrong with the attempt. For the clause embodies an insoluble paradox. The whole premise of the Charter was that governments cannot be trusted with power unchecked by constitutional safeguards, and the whole premise of the notwithstanding clause is that they can be. We should therefore not be surprised to see it abused. The governments most likely to use it are the ones who can least be trusted to do so. For as the poet Valéry said, power without abuse loses its charm.
All right. All right, I'll turn it over to our last participant, Professor Macfarlane.
Thank you. I'm not sure what's left to say. I think I have a feeling I'm going to come down more in the middle as along the lines of Carissima, in that my own view on the notwithstanding clause is perhaps a little more cynical than Dwight's, in that I do think there are grossly unprincipled ways to use this power, and I would argue that both the recent Ontario and Quebec discussions reflect a very unprincipled, maybe even dangerous assertion in contexts where you have only the rights of one side at stake. And in effect, in both of those contexts, the government is, as Chief Justice Dixon once wrote, the singular antagonist of the individual. In the Saskatchewan case, which I would defend, at the very least you have the government defending the rights of some citizens on the other side, in that you had a really messy lower court decision on school choice, and the government made a decision that it was going to defend school choice. That may not be a charter right, but it is a legitimate rights claim and a legitimate balancing act that the legislature decided to engage in when it invoked the notwithstanding clause. So I think I approach the notwithstanding clause as I do almost any other constitutional power, in that it can be abused or it can be used with principle. And that's true of any constitutional power I think we can think of, including judicial review. And one of the many reasons I know that judicial review is sometimes abused is that I'm a regular reader of Andrew Coyne. So I go back to a little bit back to why the notwithstanding clause exists. I do think it's significant that 1982 is basically the only time we have seen major formal constitutional change in this country. And so I'm not willing to be quite as dismissive as Andrew is about the significance of the clause's inclusion in the Charter project for what we envisioned, what type of system of judicial review we were entrenching at the time. And it has subsequently come to be articulated as the Commonwealth model of judicial review, that we actually somehow achieved a bit of a balance between traditional parliamentary sovereignty and judicial supremacy. I tend to believe, as many political scientists do, that in practice we do have a system of judicial supremacy. Andrew is right in that in certain cases, Parliament or provincial legislature do have room to respond to judicial decisions on the charter. In practice, my own research finds that is actually much more rare than, say, the proponents of the dialogue model suggest. So in my view, I think defenders of the Notwithstanding Clause are effectively defending judicial supremacy. Even within dialogue as originally described by Peter Hogg, we see two things pointed to that allow for this continuing conversation that Andrew is quite confident about over charter issues, the Notwithstanding Clause and Section 1. But dialogue proponents themselves are sometimes not satisfied when governments bring in new legislation along Section 1 grounds. We have seen instances, for example, Parliament's reaction to some decisions relating to sexual assault law. We have seen instances where dialogue proponents have responded to that by saying that, well, that's inappropriate, it flew in the face, it's an in-your-face reply to the Supreme Court, you should have used the Notwithstanding Clause. But of course, if the Notwithstanding Clause itself is illegitimate, then dialogue, as proposed at least by Peter Hogg and Kent Roach, it doesn't have much of an opportunity to thrive, in my view, and that's a bit of a problem. I'm going to keep my remarks short. One thing I would say in the broader context here is, let's assume the worst case scenario with the Notwithstanding Clause, and governments start to run amok. At that point, what system of judicial review do we have? I think the harshest critics of the Notwithstanding Clause are basically raising the specter that Canada will then become a system of either really weak judicial review or almost no judicial review at all. But that just raises the specter that Canada will become like the United Kingdom, New Zealand, or Australia. And I kind of have to react, ooh. I don't know that on a substantive view you can argue that our rights record is head over shoulders above the rights record of those countries. Certainly in some areas we do better. In other areas, arguably, they do better. And so the Notwithstanding Clause, to the extent that it acts as a safety valve, or to the extent that its existence is akin to a loaded gun, that loaded gun only really means that Canada shifts from a more strong form system of judicial review to a more weak form system of judicial review. It doesn't negate the role of courts, and indeed I would, on a minor point, disagree with Andrew that the Notwithstanding Clause ends the conversation. The very reason that the clause cannot last any longer than the life of a parliament is that that decision will constantly be reconsidered by successive governments over time. And I'm in fact not aware of any use of the Notwithstanding Clause that hasn't subsequently lapsed. I think to the extent that the Notwithstanding Clause poses problems is precisely some of the examples Andrew uses, and they concern me too. That said, most of the uses of the Notwithstanding Clause in a study by Svi Kahana have been described as relatively banal. We're in a room with legal experts and some hardcore nerds. How many people are aware of the details of the Yukon's use of the Notwithstanding Clause? No one on the stage, but hands up. No, you don't know that because rights weren't necessarily trampled in that instance. And in fact, that's true of most of the 17 or 18 or 21 uses of the clause through its history. If anything, I think one of the biggest problems with the Notwithstanding Clause, and one of the reasons we might be in a bit of a dangerous territory with certain governments advocating for it or threatening to use it, is that it hasn't been used, in that we haven't developed conventions around when it would be appropriate to use the Notwithstanding Clause and when it isn't. And I think the fact that it is often skirted on the precipice of irrelevance is actually the problem, not the problem that it might be used more often. But that's what we'll be discussing for the rest of this panel, I imagine.
Well, thank you all for those very interesting starting comments. Do any of you have any particular things you want to address with one another's points first, or should I ask you some questions? What do you think? Okay, I'll ask some questions. So first, this is for Professor Mathen. So it sounds like you object to responsive uses of the Notwithstanding Clause, where there's specific judicial decisions, and then there are statutes replying to those, invoking notwithstanding provisions. Can you just tell us a little more about why you might think those are problematic and you favor preemptive uses instead?
Well, I haven't really settled in my own mind how I feel about it, but I worry about the use becoming reactive. And there is a thread in the academic debate, that one of the things that is problematic is this sort of preemptive or premature use just from a single court decision. So there's a few things that worry me about that. One of this is just the idea that the government is gaming the process. Well, we're going to proceed in an adjudicative context, and we'll see if the court actually renders the decision we want. That, to me, I'm concerned about the cumulative effect of embodying that kind of attitude. And then my other observation, when you look at, we only have a couple of examples, but the position that the legislature is in following an adverse court ruling, I think, is very different from the position they're in when they're considering how important is this law to us at the outset. And I also don't think it's really that much of an ask that the legislature resolve in its own mind what is the point of departure it's taking with respect to its power to use Section 33. So I understand the idea that you provide for more space, and why wouldn't you use it as an issue of last resort? But I just feel that there are some perhaps unanticipated consequences that could trickle down into how everyone starts to look at court decisions that just give me pause.
So it sounds like those are both formal and informal concerns. Informal concerns related to how much disagreement and pathos is elicited after a decision, such that it'll affect how a notwithstanding clause is used more rationally, and maybe formal considerations about how this might affect the way the courts look at the government's, whether or not the government's actually arguing in good faith and really committed to the process of litigating rights when they're actually just going to reply to a response they lose. Is that right, that both of those things matter?
I don't know if I would put it as formal versus informal, but I guess more structural and norm-based concerns. I mean, I think the underlying norms are very important, not that much appreciated, and easily weakened. And so that's part of my concern about having a government, particularly, as I said, once the use becomes more regular, having the government face that as a really potent political demand to respond to the court decision by invoking Section 33. And I should say that I have in the past thought that there can be a place for Section 33, for example, in situations where the legislature has explicitly balanced competing interests as opposed to acting as that singular antagonist. But I think I may even be retreating a bit from that initial view that I had.
Okay, this is for Dwight. So you talk about the way the Notwithstanding Clause relates to diversity, and in that I almost hear the possibility implicit in your view that there might develop some kind of federalism in charter jurisprudence. There's been hints of this in the overall Supreme Court, in the overall charter jurisprudence, mentions of Quebec's special place as a distinct society in certain opinions. But overall, when you think about the charter, really the only part of the charter that touches on federalism, when you think about it, is the Notwithstanding Clause. It allows the provincial legislatures to reply to a federally appointed judiciary, even to courts that are their own courts of appeal that are federally appointed. Do you see your view as tied to that potentiality, or how do you think of that as a possibility?
So I would say that the Notwithstanding Clause is the one section in the Charter that most clearly enables an ongoing set of diverse responses within a federal system to different issues on which there might be real differences between the views of different provinces. That said, as you've referenced, the Supreme Court itself has actually accepted in the context of Section 1 analysis that in some contexts Quebec might be different than other provinces, and so on certain issues has made room for that to some extent. The other aspect that I would raise is that there have actually been there's been some provincial specific amendments to the Constitution, one of which is to the Charter itself, with the addition of Section 16.1 for the province of New Brunswick, and its different approach on language policy relative to that in other provinces. And these are little-known amendments, some of them, but it is there. The other provincially specific amendments have in some instances been to parts of the Constitution outside the Charter, but that relate to things that connect to the Charter in some way. So the modifications to denominational school rights in some provinces is an example of provinces choosing some different paths on some complicated issues. And we allow for that then in the amending formula to a degree through the bilateral amending formula in Section 43. But we also allow for it in the Notwithstanding Clause that different provinces might make some different choices on particular issues. And I would say that that's a positive thing in terms of fitting the Charter together with traditions of parliamentary democracy and also traditions of federalism.
That's a great answer. Do you want to reply to the accusation that the Notwithstanding Clause is the instrument for thugs?
Well, I think we've all engaged in a bit of rhetoric that's strong here. I present things a bit rhetorically at moments, and I would just say I agree with the sentiment that Emmet expressed, and probably we all agree with that. That every constitutional power is subject to the possibility of abuse. So if we have thugs in parliaments, the Notwithstanding Clause would be very dangerous. So the key thing to do is work to not have thugs in parliaments. If we had thugs in the courts, the power of judicial review would be very dangerous. And so the key thing is to have good judicial appointment systems, to have good systems overall. And in some ways, we're fortunate to be arguing about smaller things in Canada than a lot of other countries are arguing about. And we can hope that it stays that way and work to ensure that it stays that way.
Now, Mr. Coyne, surely you have a response to that thinking on the mountain.
I do. I mean, my concern is not thugs in particular, but perfectly ordinary people who sometimes do thuggish things because the context around them tells them that it's okay. People are able to persuade themselves that things that at other times and other places and by other people would not be regarded as being okay. They're able to persuade themselves that it's necessary for them to do this thing. So, for example, in Quebec right now, they're discussing the possibility of, more than a possibility, they're going to bring in a law that will tell observant members of religious minorities, you may not be a teacher in this province. You may not be a police officer. You may not hold any position of authority in the public service. I think if we stand back from that, I think we could say that's a pretty thuggish idea. I'm not prepared to justify that in the name of federalism. We have an enormously diverse country with enormous diversity and enormous disparities in the ways that different provinces approach different things, and that's all to the good. But that doesn't mean it has to be unlimited. It's certainly possible that we could say there's got to be some bedrock principles that we're going to adhere to as a society. There's got to be something that we're trying to do together here as a country, certain things that we're standing for, certain moral propositions that we're standing for, and that we're not going to allow great deviations from. There's going to be a bottom line here, and one of those, it seems to me, the purpose of the Charter was, it was to be to protect human rights. Now, having a notwithstanding clause and having certain decisions that derogate from that, from the Charter rights, isn't going to turn us into some terrible backwater. I agree with that. But I wouldn't necessarily say let's compare it to Australia or New Zealand, because I think when you're making comparisons across countries, you can't just take one piece out of the puzzle. You've got to look at the whole context of their history and their culture and their values. What I might say is compare the Canada with the Charter to Canada before we had the Charter. And there are material changes in the rights and statuses of groups within our society and of individuals within our society that I think make for remarkable progress and make us a better society than we were before the Charter. It's maybe not as apparent to some of the people here in this room, including me. Wouldn't have affected me in a lot of ways. But it would have affected our fellow citizens in really material ways. And I would be loath to rerun that experiment where we didn't have the Charter, forcing governments to come to terms with those rights and forcing them to make progress. So yeah, I mean, I'm all for federalism, but I'm for a federalism that has certain bottom lines to it.
Professor Macfarlane, I'm sure you have
I think Andrew raises a really important point, but in saying that, he raises a really interesting question. That's the counterfactual of what does Canada look like in 2019 without the Charter. I'm not sure that we would have been frozen in 1981 in terms of how we've approached rights, how we've progressed as a society, including in our view of disadvantaged groups and minorities. Countries without strong form judicial review have adopted gay marriage. I think Canada got gay marriage much earlier because of the Charter, but I don't know how much earlier. I don't know if it was 2 years, 5 years. And I don't know whether or not the Charter hasn't actually also encouraged such deference on the part of legislatures on certain contentious issues, particularly when those issues divide the governing caucus of the day. And so what we see in many highly salient social policy cases at the Supreme Court level is in fact, to some extent, a tendency among governments and legislatures to defer to courts on major questions. In this country, I'm going to use an example Andrew doesn't like, but in this country, since the 1990s, a strong majority of Canadians opposed the absolute prohibition on medical aid in dying in the criminal code. And yet Parliament after Parliament did nothing to get rid of that deeply rights-infringing law until, in fact, the Supreme Court heard the second case in the Charter era to deal with it. Now, I don't know how to construct a counterfactual of what would have happened if the Charter didn't exist, but I know that we probably wouldn't have the culture of deference to courts, that Parliament would actually have recognized that it was the body that probably should have been responsible for determining social policy in this country. And I don't know how many issues we have left to resolution by 9 unelected actors on the Supreme Court, instead of having our elected representatives actually engage on difficult questions from a more principled standpoint than they do under the existing system. I'm not advocating we should never have had the Charter. I'm not one of those political scientists. But I don't think the counterfactual is as straightforward as Andrew just portrayed it.
Professor Mathen, do you have any last thoughts on that before we open it up?
I think one thing that gets lost in some of the discussion around the Notwithstanding Clause and its use and the effects, and we get really into the institutional discussion, and I write about institutions, so that's really important to me, but I worry that we lose sight of the actual plaintiffs in the Charter cases. And for example, the fact that it's time limited, I think it is important, but 5 years is, a not insignificant amount of time to be under some law because of a determination by the legislature that the applicable charter rights are not going to be in effect. And depending on the nature of the law, I'm curious to see, one thing we haven't yet broached with Section 33 with political actors is its use in criminal law. And I think that provides a really interesting sort of crucible. Why is it that parliamentary actors, even in the face of highly divisive and controversial decisions in criminal law, were not willing to actually invoke Section 33? What are the various features that invade on them to do that? And, but I'm not sure that that's going to be sustainable if we enter into an era where, again, the demand for Section 33 is increasingly made and is seen to perhaps have not that much political cost in subnational jurisdictions. And in that context, I think that's really serious. That's something really serious to think about. Something like administrative segregation in prisons, which has been held to be cruel and unusual punishment, but undoubtedly puts serious strains on the system to actually deal with that, to invoke the Notwithstanding Clause against that, to invoke the Notwithstanding Clause against certain kinds of sentences. So I guess one of the things that's caused me to, in a sense, retreat from what was a more agnostic view of Section 33 is just a sense of who's it actually going to affect. And I would just encourage more attention to that.
Okay, thank you. Do we want to open this up to the audience for some questions?
Well, thank all four of you very much for your very interesting presentations. My question is tailored for Professor Newman, but it builds on what Professor Macfarlane mentioned, that we don't have a lot of institutional practices about how we would go about using the Notwithstanding Clause. And you alluded to some, such as a court decision that seems to be very plausibly erroneous, some sort of immediate mischief that we're combating, and then you suggest that in both Saskatchewan and Ontario, those are present. But something that hasn't really been discussed is that to the extent those were present in Ontario, I'm not sure the government thought through that these are actually present. And that seems to be democratically problematic, to put it mildly. And I guess what sort of, democratic norms would you want to have in conjunction with the use of the Notwithstanding Clause? And what role, if any, would there be for courts to enforce those? So, thank you very much.
Well, on the second question of what role there is for the courts to enforce those, I'd be fairly skeptical of starting to put in place judicial review of use of a clause that's meant to be precisely to respond to situations where courts may have gone wrong. Speaking to the first point, I guess, I mean, we do need to develop a set of criteria and conventions around it, and we would have seen those develop better if there'd actually been more use of it over time than even these 20 or so cases, because the details of those are little known in most instances. And so we certainly can talk about criteria that justify the use. Your suggestion, though, that although I've said those were present potentially in Ontario, that nobody thought about those, raises a complication here, because there are people that have put the view that, for example, a government proposing to use it or a legislature proposing to use it should have to offer a set of reasons. And I actually disagree with that if the idea is a set of reasons that look like the reasons from a court. I don't think we should start judicializing legislative bodies by insisting that they offer sets of reasons that look the same as those coming from a court. I think there will be instances in which politicians who come from the people aren't articulate about the law in the same way that a court might be. And that doesn't mean that we should ignore people because they're different than lawyers sitting in a room somewhere. I think we need to look behind what's there to see, are there good reasons there, and argue about that within our democratic politics.
All right, next question.
Thank you for your presentations. When I was in law school, I remember there was a meme going around that said something like, if you didn't want to violate the charter, you shouldn't have broken the rule that the Supreme Court hadn't yet pronounced. So that there was a certain element of unpredictability in what might happen in charter-based decisions at the Supreme Court. And I'm wondering, just thinking about predictability, do you think that there's, given that that's a hallmark of a common law system, do you think that that is also possibly a basis for saying that something like a Notwithstanding Clause has a place in a charter?
I'll answer that first, if you like. You know, the caution was put to us that we shouldn't idealize the legislatures more than we're sometimes accused, people like me are accused of idealizing the judiciary. So if we're talking about stability, let's look at the Doug Ford case. It was the legislature, it was Doug Ford, that introduced the element of instability in that case by bringing forward legislation in the middle of an election campaign to fundamentally alter the rules of the election. Now, I grant that the lower court ruling that overturned it was a bit wonky, and the reasoning was more than a bit of a stretch, but that's what we have appeals courts for. It seems to me that predictability is relative degrees of predictability. No system and no branch of government is going to give you exactly what you want, whether in predictability or any other quality. It's always going to be relative degrees. But a process where people agree to follow the system of law and the system of appeals to higher courts, to me, has a higher degree of predictability than essentially one guy. And I think this is a larger context that we ought to bear in mind is when we're talking about the rule of law or talking about democracy, is how flawed and fundamentally flawed our democracy is. So in the case of the Ford administration, you have a guy who won the leadership without winning a majority or even a plurality of the vote within his own party, on the basis of which he then was able to command his caucus unilaterally, because they all depend upon his sole power of appointment to cabinet. He was able to push this through cabinet because they're all in fear for their jobs if they crossed him. So essentially you got legislation rewriting the laws of an election at another level of government that was the product of one person. And if we're looking at the whole system of checks and balances, the only thing remaining to introduce some element of stability and some element of legal predictability there was the courts.
Or the Senate.
From which he then absented himself. Well, not at the provincial level. Provocateur. That was the last line of defense against essentially arbitrary rule. And I think if we're talking about these qualities, we have to look at them in that larger context.
Someone earlier mentioned the idea that the notwithstanding clause is often mentioned in circumstances to which it doesn't come 15 football fields away from actually applying. And I do think there's something distinctive about the Charter of Rights. Earlier, Andrew compared it to the division of powers context, where I think the court actually plays umpire. And the umpire analogy fits a lot better. Under the Charter, the court is confronted with profoundly complex moral and ethical questions of complex policy matters, and the fundamental decision-making basis is policy analysis. That's inevitably what the Oakes test lends itself to, evaluating proportionality and salutary versus deleterious effects. This is a game in which these 9 people are not necessarily always well equipped to play. There's something distinctive about this area of law that I think a safety valve is appropriate. And I think the predictability and coherence factor is important there. I don't know that anyone in this room would say that freedom of association jurisprudence, equality rights jurisprudence, more recently religious freedom jurisprudence has been all that predictable, stable, or coherent. And that's because a lot of the cases, particularly under those provisions, but others as well, involve competing interests and balancing of rights interests. And there's no reason why a legislature shouldn't have a degree of coordinate say over how to balance those interests. And if it's through the use of a legislative power like the Notwithstanding Clause, that's fine. I will stand in the streets to protest its abuse as I would any other power, but I think there's a reason we decided not to opt for a full-on system of judicial supremacy.
Do any other commentators have thoughts?
If I can mention one other predictability-related use, we actually have an instance on record of a Supreme Court justice urging the use of the Notwithstanding Clause, or at least raising it, in the context of the application for an extension on the Carter decision on assisted suicide. And when the government, the new government went and was seeking more time to respond because the initial suspended declaration had been cast over an election period when no government was going to be able to sort things out. Justice Brown, in the context of oral argument, said, well, the federal parliament could use the Notwithstanding Clause to grant itself an extension. And in circumstances where it needed to and a court weren't granting it, I could actually see that as being an appropriate use for a parliament to give itself more time to respond to something within reason. We've seen a little bit of a trend away from suspended declarations just in recent months. And we might actually see then more need for that in some context where a court doesn't foresee the challenges of responding to a decision.
I would accept the notwithstanding clause if we could entirely end the process of suspended declarations, which I think are an abomination, so I just thought I'd put that on the table.
Okay, next question.
Hi, I have a question for the whole panel. Given the particular bicultural, bilingual, binational history of our nation, of our country, I think of Wilfrid Laurier's comment that this country is two nations warring within the bosom of the state, and that the examples that have been given in Saskatchewan, which at the end of the day, one of you have commented was perhaps more sympathetic to an outsider group, and then in the Ontario decision has more perhaps of a bureaucratic element, and the examples given in Quebec I find have far more dramatic implications as to people who believe in a free and democratic society. Is it safe to say that if this is a loaded gun, that were the bullet to go out and were it to wound, it would most likely be Quebec's finger on that trigger? Thank you.
Yes and no. Every government, every provincial government is capable of overriding rights. And we've seen examples of that. The danger in Quebec, I will say, is that you have a majority that sees itself as a minority. And that's independent of language or culture, that's just the facts of the situation. And when people feel themselves to be a besieged minority, they are more inclined to give themselves license to do things that other populations might not. And they may well be right in some cases. So there are different circumstances, and people have to look at these things through that lens. But it's rife with potential for overreach, and I think we've seen examples of overreach.
I might have allowed for that possibility, greater possibilities, some years ago, but certainly in the context of religious minorities, I no longer believe that there's that much of a margin of difference in how various communities in Canada regard, let's say, threats to culture and other values posed by this particular practices of religious communities. And one thing I've often said is that the public support in general for the Charter is often accounted for as deep, but I think it's also highly contingent on how those underlying values are communicated by political actors. And if you have a shift in how those political actors talk about the Charter and talk about their obligations, for example, once they actually enter into the judicial adjudicative realm, I'm not convinced that there will be much in the way of pushback, at least among significant communities.
Do any other panelists have comments on Quebec and the loaded gun in either official language?
Well, I'll just add, picking up on the point that was referenced, Quebec has a majority that is a minority within North America, and that does put it in a different position relative to other provinces. And second, we shouldn't trivialize the discussions that go on in Quebec. Very lengthy discussions have gone on around issues in a different way than those issues have been considered elsewhere in Canada. But if they do come to some view that's different than elsewhere in Canada, it will be on the religious issues that they're confronting. It will be after decades of discussion. And it may well be that it's a decision that many of us profoundly disagree with, and I suspect they'll make a decision that I profoundly disagree with, but they are in a very different position relative to other provinces, and it's not something that they've done just on a whim to attack people. so much as something that's followed a very prolonged discussion, and that's what I'll say on it.
All right, next question.
My question would be primarily, I guess, for Mr. Coyne, and it's to do with the potential thuggishness of legislators. I'm also of the opinion that, I think I agree with you that legislators can be thuggish in the sense that they promote sort of a tyranny of the majority. I think courts can also act as perhaps upholders of thuggishness, disregarding minority interests. You mentioned the Brown versus Board of Education. You can go back and say, well, the Supreme Court also decided Dred Scott, for example. And I think that what a court does is not, they don't act as vehicles for majority opinion, but they do act as vehicles for elite opinion, just by the nature of what a judge does. And sometimes elite opinion equally disregards the interest of minorities. The way the change in U.S. jurisprudence between, Dred Scott and Brown versus Board of Education is one thing. You can look at a more recent example and look at, and this has already come up, but Rodriguez decided in 1996, said that the prohibition on medical aid in dying was fine. Carter overturned it only 20 years later. That kind of change makes me wonder how much, if rights are being severely infringed, are the courts really doing a better job? And if they're not, and perhaps you disagree, why would we then prefer the courts have such trepidation about and giving the legislators the power to overrule the court? Thank you.
Your point's absolutely well taken. It's a point that I made, that oftentimes the courts, in my opinion, fall down on the job of upholding charter rights. So the caricature that's made of them, and oftentimes in these kinds of forums, that they're just sitting there with their finger on the trigger, just waiting to overturn laws because they're just so rights happy, I just don't think is necessarily conforms with the actual case. Lots of decisions they've made, and Emmet referred to some of my columns, have been about situations where I think the courts failed to do their job. I start from the standpoint that I'm biased towards liberty. I want, at all times, governments to have to justify every infringement of liberty. They can justify them, and they do, but they always should have to. So we shouldn't be even-handed between infringements in liberty and excessive liberty, if you will. That I would rather start from the standpoint of every incursion on freedom has to be justified rigorously. What we have with the Notwithstanding Clause, it seems to me, is an imbalance in the other direction. And I mentioned this again in my remarks. People want to have the Notwithstanding Clause to ensure that the courts don't overreach, that they don't strike down too many laws. We've got no comparable balancing wheel on the other side that says, what do we do if courts fail to enforce the Charter? So the bias is going to be, therefore, against freedom. We've got a system in which governments have been empowered to overrule things that strike down laws, that in other words, that limit the capacities for governments to infringe upon people's freedom, but we don't have any similar safeguard on the other side. So yes, I'm sometimes disappointed by the courts, but they're all we've got to rein in laws that go against not just the principles of the Charter, but the intent of the Parliament that passed it. So I don't think it's a matter of courts versus parliaments in this case. It's a matter of arbitrary rule versus rules-based law.
Although it doesn't count as an enforcement, I do just want to point out that it is possible for the legislature to change its mind even after it notionally wins a case, and to return to the table and actually to enact provisions that more or less track what the claimant was arguing. That happened in 1995 following an income tax case called Thibodeau, which split, very interestingly, completely along gender lines. It was about the deductibility of certain expenses. And the government of the day, which had, defended the law quite vigorously, concluded, for a variety of reasons, that in fact it was appropriate to amend the law in some respects to correspond to the concerns that were raised about it, notwithstanding the fact that it had prevailed in the Supreme Court of Canada.
Can I just follow up with Mr. Coyne? Isn't it simplifying it a bit to say that that presumption of liberty is in favor of the courts and their conception of rights? I mean, presumably we agree that there can be reasonable disagreements about rights. So in some sense, doesn't Section 1 actually do the reverse? Doesn't it force the government to admit an infringement and then justify that on the basis of whatever its view of interests are? So doesn't it in some ways turn the tables on the, Section 1 turns the tables in some sense on the legislature, and Section 33 reverses that and allows it to counteract that. But both Section 1 and 33 point in opposite directions that way and kind of balance each other out.
But again, there's an imbalance between them, and I said this in the remarks as well, is reasonable limits. There's a body of jurisprudence surrounding it. There are principles informing it of showing that the limits are reasonable. If you can't show that the limits are reasonable, then you can't save the law in question. No such limits and principles and guidelines apply to notwithstanding. You can invoke the notwithstanding clause for any reason whatever. You can only do so within particular parameters of which sections of the Charter it applies to, which is a question that the parliamentary sovereigntists don't seem to trouble themselves too much with. So it only applies to certain rights and freedoms and not others. But it doesn't have any constraints upon it except the notion that you have to pass it again in 5 years.
As the moderator, I should turn it over to the next question, not argue with the panelists.
Surely you would agree.
Thanks to the whole panel. Throughout the discussion, we heard quite a number of weaponized metaphors. So to the extent that it falls somewhere between, an armed society is a polite society and mutually assured destruction, if the idea or the merit of the Notwithstanding Clause is that it reduces the moral hazards of an unchecked judiciary, is there anything that could be codified or formalized that any of the panelists would suggest that would achieve the same effect without the sort of big gun or nuclear option? And I guess related to that, does it have any possible therapeutic or regulatory function relative to populist impulses?
Yeah, that little tack on at the end is like a whole different question. So what have other jurisdictions done? So when the United Kingdom brought in the Human Rights Act, it said that its courts could make declarations of incompatibility, but could not in practice actually strike down or read into legislation. New Zealand has something even weaker than that, where only recently they've decided that the court can even acknowledge if a law has violated the New Zealand Bill of Rights Act, which is perhaps goes far too much to the other end of the spectrum. But what could we come up with to bring some balance if we don't want the notwithstanding clause? Maybe at the Supreme Court level, the strong form powers of judicial review can only be exercised if the court is unanimous in its opinion.
I'll just say a couple of quick things. I just think we sell short, and I've been the one who's been most skeptical of the legislature here, but I think we sell short the creative abilities of our legislators if we don't think they can respond to an adverse court ruling in a creative way that maintains the purpose of the legislation that they were dealing with, but does so in less objectionable ways. I think that is selling them way short. I think we've seen examples where legislatures have gone back to the drawing board and have come back with legislation that actually met the court's objections. Point one. Point two is, and that parenthetical remark that you dropped in at the end of the question, I think is very significant. And it relates to a lot of what Professor Mathen has been saying. Some people might have been more prepared to accept the Notwithstanding Clause than I am, in the context of an idea that there was some kind of consensus around when and if it would be used, that there were some kind of reasonable bounds that reasonable people in power would be applying to it. But we live in an unsettling age when very unreasonable people and unreasonable politics are afoot, for reasons that we can all talk about at length. And in those circumstances where those understandings and those consensuses no longer seem to exist across a wide range of fronts, not as bad here as it is in the States, but nevertheless that kind of thinking is afoot, then that loaded gun becomes a lot more dangerous than it might have been in previous years.
Do any other panelists have thoughts on populism? All right, next
Many.
question. Asher.
Okay, first of all, thanks everyone. That was a great panel. My question sort of picks up on the last one. So at the risk of sort of sparking a national unity crisis, I'm wondering what your thoughts are on the power of disallowance as a check on the Notwithstanding Clause. And for those in the room who aren't familiar with that, disallowance is from the 1867 Constitution. It is sometimes called a dead letter, but it's still there. It allows the federal government to invalidate provincial legislation. There has been a convention against using it, but conventions can evolve and change. That's the actual living tree. And we could bring back a convention to use the disallowance power in the unique circumstances where a provincial legislature has used the Notwithstanding Clause in a thuggish kind of way. And so I'm wondering what you think about that, because the disallowance power in many ways is the inverse of the Notwithstanding Clause. The Notwithstanding Clause was put into the Charter at the behest of the provinces. The disallowance power was put in as a means of checking provinces by Parliament. So in a sense, they could be argued to work in tandem. So I'm wondering what you all think about that, and if you think it would result in the breakup of the country, or if we could avoid that.
I think you're undercutting the importance of the Convention of Disuse at this point. There aren't a lot of things with such a high degree of consensus in Canadian constitutionalism as the fact that the disallowance power is viewed as spent. I think it would precipitate a huge constitutional crisis. I think it would be akin to a Governor General refusing to heed the advice of a government that still enjoyed confidence. Like, I think it's that solid a convention at this point.
To me, federalism is a priori, obviously, well, not just to me, historically, everything structurally, it's a priori rights. And I think once you're in the realm where a federal government would seriously consider using the disallowance clause, perhaps because the use is so egregious in a jurisdiction, you are extra legal. You are talking about a political disjunct or fissure that I don't think can be resolved by use of the disallowance clause any more than Dred Scott the Dred Scott decision was able to stave off the ultimate breakdown of civil organization.
I might have a couple more kind words for disallowance. Much as I'd like to delegitimize notwithstanding, I'm not sure I'm prepared to just simply write off disallowance because some scholars say it's been fallen into desuetude. Obviously, one would want to be very sparing in its use. It's interesting, though, the ironies of the situation, because prior to the Charter, if we want to talk about constitutional understandings, at our founding, the notion was very much, the idea was that one of the roles of the federal government would be to protect local minorities from local majorities, that the federal government, the executive authority of the federal government, would be one of the things that would protect rights. This would, in a sense, be a return to that. If notwithstanding had been used to basically neuter the Charter in important ways, then obviously it would require a particularly extraordinary situation. But if the Charter, by virtue of the Notwithstanding Clause, was failing in its appointed role of protecting minorities from serious depredations on their rights, in extremis, maybe the federal government would have to resume its original Confederation role.
I guess I would see disallowance as illegitimate, not just because of disuse over time, but because the circumstances in which it would come to be applied today would be very different than those of a certain colonial period and the things that it was attached to. But we could learn more about it reading the book that Scott Reed has done. There might be references in there. The other thing, though, that I do want to add is that there would be other ways of challenging a thuggish province. First of all, by critique within the country itself, but there would also be means by which that province would see a genuinely thuggish step taken to international bodies. And if it were doing something genuinely outside the bounds of what can be done, that would receive a response. Now, if a country does something analogous to what Western European countries are doing and having upheld at the European Court of Human Rights, it might be critiqued within Canada, but might not receive a, rejection at the international level.
Okay, thank you.
All right, I think we are out of time, unfortunately, so I apologize to the two questioners. I should have asked for more people at a time. That's my fault. But join me in thanking our excellent panelists for a very interesting discussion.